Lecture 3, International Courts of Justice, Law and Procedure Applicable Law. The key provision in this matter is Article 38 of the ICJ Statute 1. The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom, as evidence of a general practice accepted as a law. Circa. The general principles of law recognized by civilized nations. D. Subject to the provisions of Article 59. Judicial decisions and the teachings of the most highly qualified publicists of the various nations, as subsidiary means for the determination of rules of law. This provision shall not prejudice the power of the court to decide a case ex aequo bono, if the parties agree thereto. 2. The proceedings in contentious cases, the official languages of the court shall be French and English. If the parties agree that the case shall be conducted in French, the judgment shall be delivered in French. If the parties agree that the case shall be conducted in English, the judgment shall be delivered in English. In the absence of an agreement as to which language shall be employed, each party may, in the pleadings, use the language which it prefers. The decision of the court shall be given in French and English. In this case, the court shall at the same time determine which of the two texts shall be considered as authoritative. The court shall, at the request of any party, authorize a language other than French or English to be used by that party. Equality of the parties. The equality of the parties is a fundamental principle of judicial proceedings in general, and the ICJ is no exception. The principle of the equality of the parties requires that the same and equal rights and opportunities must be given to both parties in disputed proceedings of the court, such as the same number of written pleadings and the same amount of time to present their written and oral proceed. The burden of proof apart from the procedural rules on the form and timing for the submission of evidence. The ICJ statute and the rules of court contains no guidance concerning the exclusion of evidence. The general rule of the burden of proof can be summarized in the maximonis probandi incumbit actori, which means that the actor bears the burden of proof. Experts in relation to the assessment of evidence. Some mention must be made of the role of experts in judicial proceedings before the ICJ. Here 5 categories of experts can be identified: I. Court-appointed experts, E. Party-appointed experts, E. Expert counsel, IV. Invisible experts, and V. Assessors. Decisions of the court. Decisions of the court are a production of the collective work of the bench, and all judges, including dissenters, are to participate in the drafting process. All questions are to be decided by a majority of the judges. The quorum is 9. Abstentions is not permitted. The judgment shall contain the names of judges who have taken part in the question. The judgment shall be signed by President and by Registrar. If the judgment does not represent in whole or in part a unanimous opinion of the judges, any judge shall be entitled to deliver a separate opinion. A judge who agrees with the conclusion of the court but for different reasons, or who prefer to give his own reasoning, may a separate opinion, while the judge who is against the majority opinion may deliver a dissenting opinion. Non-appearance: whenever one of the parties does not appear before the court or fails to defend its case, the other party may call upon the court to decide in favor of its claim. The court must, before doing so, satisfy itself not only that it has jurisdiction in accordance with Articles 36 and 37, but also that the claim is well-founded in fact and law. Preliminary objections is defined as a formal step by which a respondent raises a question that it contends should be dealt with separately before any other issues in the proceedings is examined. Under Article 79, 1 of the Rules of Court, preliminary objections can be divided into 3 categories. 1. Objection to jurisdiction. 2. Objection to admissibility. 3. Other objections: admissibility of disputes involving highly political issues. Some argue that due to its nature, highly political disputes are beyond the function of the court as a judicial organ. Objections to the admissibility of a specific case on the basis of the doctrine of highly political disputes have been repeatedly filed in cases before the some cases. The admissibility of highly political disputes was also questioned by the members of the court.